Hello, my name is Sunzida Ahmed, and my Gardner research project was a venture into prosecutorial discretion in environmental crime, and my research advisor was Professor Milton Heumann. For my research, I focused on federal environmental prosecutors. These prosecutors represent the federal government in criminal prosecutions and in certain civil cases relating to environmental violations. Now, environmental prosecutors have been subject to a lot of scrutiny because of how broad their discretion is. Now, this broad discretion arises from two major causes. The first is that prosecutors have absolute and unreviewable charging powers, meaning prosecutors can unilaterally decide whether or not to charge a case criminally and which charge to pursue. And these decisions are rarely reviewed by courts. The second reason their discretion is so broad is because the environmental laws and statutes themselves are vague, and they don't differentiate between conduct that constitutes civil enforcement and conduct that constitutes criminal enforcement. So environmental prosecutors largely have to make that distinction themselves without the help of the law. Now, given this broad prosecutorial discretion and statutory system, for my research, I wanted to contextualize prosecutorial behavior in environmental crime by trying to answer the question of what factors influence an environmental prosecutor's decision to pursue a criminal charge, and a sub-question connected to this is what are the differences between civil enforcement and criminal enforcement cases. Now, for my research, I found that there were two factors that have historically had an impact on a prosecutor's criminal charging decision. The first influential factor is political administrations. Now, to describe this impact, we can consider the presidential administrations of President Obama and President Trump. President Obama instituted an environmental policy that prioritized cutting carbon pollution, expanding the clean energy economy, and protecting natural resources. And these policy decisions had an impact on environmental prosecutions, as we saw that there were about 116 criminal pollution cases per fiscal year during his first term. Now, on the other hand, President Trump prioritized deregulation and minimizing the EPA, and this also had an effect on the criminal pollution cases per year, as we can see that there were about 70 cases per fiscal year during his first term. Now, the second influential factor on prosecutors' decisions to criminally charge is what's known as the aggravating factor hypothesis. Professor David Ullman from the University of Michigan Law School hypothesized that criminal enforcement of environmental violations has been limited to conduct involving one or more of the following aggravating factors, including significant environmental harm, deceptive or misleading conduct, operating outside of the regulatory system, and repetitive violations. Now, given these two factors, for my research, I wanted to expand on Professor Ullman's aggravating factor hypothesis by including a civil case comparison and also accounting for the potential political influences. Now, to narrow my design, I only focused on pollution cases, and three major pollution statutes within the United States are the Clean Air Act, the Clean Water Act, and the Resource Conservation and Recovery Act. For each of these statutes, I chose two cases, one ending in civil enforcement and one ending in criminal enforcement. There were 6 cases for each administration, so my data set had a total of 12 cases. And for each one, I had a 5-category evaluation process to ultimately discern if an aggravating factor was present, and additionally, why that case might have been pursued criminally or civilly. Now, after conducting this research, I found that the results uncovered some major findings, and I included them here in 2 categories. Now, for the criminal-civil comparison, all of the criminal cases had at least 2 aggravating factors, and surprisingly, almost all of the civil cases had at least 1 aggravating factor. The most common aggravating factor for criminal cases was significant environmental harm and deceptive conduct, whereas the most common aggravating factor under civil cases was repetitive violations. And one interesting point about civil cases is that none of those cases contain deceptive or misleading conduct. Now, for the administration comparison, President Obama had an average of 2 aggravating factors for criminal cases, whereas President Trump had on average 3 aggravating factors for criminal cases. The most common aggravating factor under the Obama administration was deceptive conduct, and the most common aggravating factor under Trump was significant environmental harm. So, what do all of these results tell us? Well, I was able to discern 4 major conclusions from these findings. The first is that aggravating factors are not triggers for criminal prosecutions. By virtue of civil cases also having these factors, they seem like a likely commonality between all judicial enforcement mechanisms as opposed to a trigger for just criminal prosecutions. Moreover, across both administrations, prosecutors tend to reserve criminal enforcement for cases that include significant environmental harm or deceptive and misleading conduct. And civil enforcement typically contains defendants that do not engage in deceptive conduct. Finally, given that for cases under Trump, there was a consistency of 3 aggravating factors as opposed to 2, and a high frequency of significant environmental harm, it stands to reason that for a case to have been criminally prosecuted during the Trump administration, the violation had to have been especially severe. Now, the conclusions from this research indicate that because prosecutors seem to be reserving criminal and civil enforcement for cases that involve aggravating factors, their behaviors are coherent and traceable, which may ease a lot of the concerns about their broad discretion, which I talked about earlier. Moreover, an important factor to realize is that prosecutors are subject to transient political changes, meaning that prosecution levels are also subject to those same changes. That concludes my research. Thank you so much for listening, and I hope you were able to learn something.